everyone. I'm Amy Davis from PGC Group. I'm the Director of Strategic Operations and Growth and support our clients with US expansion. Lots of clients that I've spoken to about recently ask me all different types of questions about US expansion. But one of the things that I often get asked is about business terms and how recruitment firms and other companies can mitigate their risk of doing business in the US through their contractual terms. So I've invited a special guest along today to help us go through that in a little bit more detail and break down some information that I hope is helpful and useful to everybody watching or listening in today. So before we crack on, I would just like to introduce our guest, which is Jonathan Strassberg of Truecourse Law. And Jonathan, I wonder if you could tell us just a little bit about you and what you do, if that's okay.
Absolutely. Thank you so much, Amy. It's a pleasure to be here talking to you today. Well, what I do, I am an American attorney at law, as well as an English solicitor. I came to the UK in 2007 and requalified as an English solicitor, and noticed that there was a big, did my networking and all, and noticed that there was a tremendous gap in the market here, that large companies wishing to do business in America had all the professional assistance they needed. But SMEs, smaller companies, really didn't. And they were left out in the cold when it came to US legal advice. And they were also left out in the cold when it came to US accounting advice, all manner of cross-border advice, including insurance and whatnot. So I pursued that niche. And really, for the last 9 years, I've been moving from strength to strength. Specifically with regard to recruiting, which is sort of what we're going to be talking about today. I went to a wonderful Select USA, which is just sort of the commercial arm of the US government, reaching out for direct investment in the United States a few years ago. And I met one of the people who works in the New York office. And I actually have a very vivid memory of the two of us having a cup of coffee and talking that we should really chat to one another. And here we are years later, and I now have recruiting as a significant subsector of my practice. I started out work as a corporate litigator in Manhattan and Chicago, and that was quite nice. I did a stint in property development as a lawyer as well. But here in the UK, my practice is helping UK SMEs that wish to trade with, expand to, or operate in the US market. And I handle everything from beginning to end of that, and introduce my clients to all the other professionals they might need in order to hit the ground running in the United States.
Amazing. Just need to say, obviously, that coffee turned into a great relationship with one another. We've got lots of clients, mutual clients now. I will so often signpost clients to you, and the feedback is nothing but amazing, Jonathan. Everybody loves working with you. So we know just, how key it is, those SMEs that need this specialist support. And particularly, as you say, from a US qualified attorney and not just an English solicitor. And the fact that you're both is kind of amazing. So you're pretty much a bit of a rock star in our eyes. So just thinking about some of those clients that mutual clients that we've worked with, it'd be great if you could just maybe tell our audience a little bit of just how exactly you've supported specifically staffing firms, recruitment agencies in that spectrum of kind of US expansion.
Right. Well, they're basically, this will harken back to one of our prior conversations. There are basically two sorts of clients I get in the recruiting business. Those that are trading, who are not trading in the US yet, but have the opportunity to sign a wonderful contract or get a wonderful client in the US. And they're not really thinking about expansion to the US, but they are thinking that they'd be best protected if they had US terms to operate under. And the other client is, the other sort is the client that is doing their homework in anticipation of expanding to the United States. And usually that takes the form of a subsidiary. And I'll speak about that category first. There are basically three components to a US expansion, speaking very, very generally. The first thing you want to make sure of is that you do no harm. And what I mean by that is, it's successful companies that are thinking about going to the US. They've already established themselves in the US, in the UK. They have a following, they have goodwill, they have assets and reputation. You don't want to harm any of that during your expansion. So your first task is to protect your UK limited company.
Yeah.
The second task is to recognize, and this is where a lot of people make a mistake, that while you are going out to the US to make money in the US, that's only half the story. You're more times than not, you're going out to the US to make money in the US and bring it back to the UK. So what that means is you have two tax authorities that you have to consider. And you have to consider those tax authorities in a cross-border context. Now, in approaching that scenario, there are typical things that we do. There's the bog standard sort of structure, but there will always be cases that aren't standard. And for those cases, well, for all cases really, what we like to do is to have myself, their lawyer, as well as a cross-border accountant on the phone together with our client to make sure that this second prong of expansion is satisfied, and that's getting the best aggregate tax treatment that my clients can get. And the last prong is bringing together all the various professionals that my clients will need. So yes, I am a lawyer, but I'm also a business consultant. And that's sort of a product of having networked in the United Kingdom for many years and building this practice really from the ground up. So I want to make sure that my clients have an understanding of cross-border insurance issues, currency exchange issues. Once they get to America, that they have an understanding of payroll and health benefits issues, trademark issues, immigration issues. And we want to make sure that my clients, who generally come to me with far more questions than answers, and sometimes not even knowing the right questions to ask, that they really are able to fill in this canvas, and they are able to have borders around all the issues that have to be addressed, and invariably that is done.
Yeah.
So that's the first category. The second category I mentioned are those clients that come with a specific opportunity to work with a specific client in the United States. And for them, I'm usually very thankful. I'm always very thankful that they've called me before they've signed the contract. Because those that often call me after they've signed a contract have to call a litigator rather than me. And they're, comparing US and UK contracts, they can look very similar. And to a layman, they would seem very similar. But in the event of a dispute, the way those contracts are worded, structured, and all the rest would really leave a UK company at the mercy of their US client if they've got the wrong contract. So those are the two.
Yeah, definitely. I mean, we see exactly the same. That's really similar to what kind of we see in PGC. And although the advice is similar, they're at a different stage of their journey. And it's about kind of meeting them where they are and giving them what they need to set them up to win in the US. So just coming back to them, in terms of those actual terms of business with a US client, lots of clients will ask me, why do I need to change my UK terms to do business in the US? So, what are some of the things to consider when they are looking at adjusting the terms to do business with a US client?
I'm sorry, the question is.
So what are some of the things that, a client needs to consider when agreeing terms of business with a US client? Right,
okay. So here's why it becomes complicated, and here's why it's a very serious issue. There is no treaty between the United States and the United Kingdom that requires either country to honor the court awards of the other country. So let's say that you're a UK recruiter, you haven't worked in the United States, you have this wonderful opportunity to work with a client in the US. And rather than waste time with your lawyer, you just go ahead and send them your UK terms. Well, you might be absolutely fine. So for instance, if you have if the work is going to be retained search for a permanent position, then you'll probably take maybe a third of your money up front, and maybe at a short list you'll get a third of your money. But let's say that the last third you provided the candidate, and the client decides not to pay you, and you have these terms that are pursuant to UK law. Well, you're free to go sue the client in the UK, and you'll probably win. But the UK court can't force your client to pay. And the judgment you get from the UK court doesn't mean anything in the United States. So what are you left to do? You have to bring that judgment to a US court and ask a US court to enforce that judgment. And the US court will have the discretion to either enforce it or not enforce it, or relitigate the case. And regardless of what decision it makes, you can be assured that your litigation costs will be at least twice as much as they would have been if you had used US terms. So that's the sort of example that we go through. On the other hand, let's say that you have something more complicated, like a temporary placement of employees. This is not the corp-to-corp situation. This is where you place people who are on a payroll. And let's say something goes terribly wrong, and somebody associated with the client or somebody associated with the client or third party suffers a terrible loss. And you have these terms that are pursuant to UK law. Well, the UK under English law, well, I shouldn't say UK, pursuant to English law. In English law, there is a particular way of limiting your liability. And it's very well settled, and it will limit your liability in England, but it will not limit your liability in the United States.
Right.
And the problem is, if you read that clause to any business person in the US, if you would take one of those clauses and read it to a business person or a pair of business people from the US and the UK, they would seem like they're saying the same thing.
Okay.
That they're not. So, consider when you're going to the US, if you're going to use UK terms, that if you don't understand what your risks are, you may find yourself in a terrible position in the event of a dispute.
Yeah. Are there any, so I suppose in that then, you've probably already highlighted, but what would you say are kind of the most common mistakes that you've seen, particularly staffing firms make when it comes to this?
When it comes to using terms?
Yes.
Terms and conditions? The most common mistake is scratching out "this agreement shall be enforced in accordance with English law" and inserting the law of some, United States, of a state within the United States, New York or California or whatever. Yeah. That's by far the most common mistake. And so you end up having what I call a Frankenstein contract, because it says that the contract should be interpreted and enforced in accordance with, for instance, New York law, but the contract recites statutes that exist in England and do not exist in the United States. So what is a US court to do with that? They have to start chopping up provisions and disregarding them, which leaves holes in the contract. And where this leaves a party is in a very unsettled state, where more issues have to be litigated in order to find a resolution. Now, I will tell you that when I say litigation in America, what I mean is settlement negotiations. Yeah. As a matter of fact, only 1% of commercial litigation in America ever goes to trial, believe it or not. 99% becomes settled. And it's rarely settled on the basis of who has the best argument. It's usually settled on who has the most powerful bargaining position in terms of financing, because litigation in America is a war of financial attrition. Whoever has more money to spend on litigation is more likely to get the settlement that they want. So yes, it's a much more mercenary sort of system in the US, and that really underpins everything when it comes to US contracts. And if there's one fundamental thing to understand about US contracts, is that They are a properly drafted U.S. contract is designed to make you an unattractive target for litigation.
Yeah.
Because in America, it's not so much about who's right and who's wrong, but rather about whether you are an attractive target for a litigator to drag through the courts, make you spend lots of money or settle for an unfavorable amount of money.
Wow. That's
yes,
crazy.
it's unfortunate, but that is the reality. It is somewhat of a game of chess.
Yeah, sounds pretty crazy. Okay, if you could kind of leave our audience today with maybe just kind of one golden nugget of advice, what would that be?
It alludes to what I just talked about now, and that is when you think about the financial impact of a dispute in America, when you try to assess the financial impact of a possible dispute in America, this is a very different exercise from the way you would think about the financial impact of a dispute in the UK. In the UK, if you're thinking about suing somebody, you have to think long and hard, because if you sue and you lose, you'll have to pay the other side's legal fees.
Yeah.
The default rule in America is that the loser does not have to pay the legal fees for the winner. And this, as I mentioned before, this underlays everything. So what it means is that do not venture into serious commercial transactions in America without the benefit of legal advice. Sometimes I tell my clients to use the UK terms because the risk is so low and they're probably better. But as the risk increases, as your risk increases, you have to more and more seriously think about using US terms.
Okay. Perfect. That was fantastic. Thank you so much. I really appreciate that. And I'm sure
was that okay?
It was perfect. And I'm sure everyone listening today will have taken so much from that, Jonathan. So thank you so much for your time. I really appreciate it.
I hope I didn't run off at the mouth too much for you.
I'm just gonna